Good morning, everyone. I'm Margaret Hinkle. It's my privilege to serve as the chair of the Post Commission. I welcome everybody for our 53rd public meeting. And with that, let me take a roll call, please, of the commissioners in attendance. Commissioner Bluestone?
I'm here.
Commissioner Calderon?
Here, good morning.
Commissioner Crispin?
Yeah, good morning.
Commissioner Hall?
Present. Good morning.
Commissioner Kajrosian?
Hi, good morning. I'm here.
Commissioner Luma?
Good morning, I'm here.
Commissioner Talley?
Morning, present.
And absent today because of a conflict is Commissioner Baker. We have a quorum. Let me move next to the approval of the minutes. The consideration of the minutes of our July 18th, 2024 public meeting. Is there a motion to approve those minutes?
So approved. So moved.
Is there a second to that motion?
Second,
Commissioner Bluestone?
Yes.
Mr. Calderon?
Yes.
Mr. Crispin?
Yes.
Commissioner Hall?
Yes.
Mr. Kajrosian?
Yes.
yes,
And Commissioner Talley?
Yes.
Thank you. The minutes are approved. Moving on, please, next to the Executive Director report. Enrique, you're up.
Thank you, Madam Chair, and good morning, commissioners. I will share my screen as I typically do to walk you through a short presentation that constitutes my Executive Director report. So if you give me a minute. Can everybody see this screen? Thank you. So on my report, I will provide updates on two topics that I typically speak about: the certification efforts and the disciplinary records project. I will also close with a brief financial and administrative update, and also tell you about important new functionality that we have in our new website, which I will briefly demonstrate at the end of my remarks. As I have reported in the past. Oh, is there a question or comment? No. Okay. So as I have reported in the past, the certification team continuously updates and reconciles records and status of officers, given that they have the big task of managing a large data set, and that is 21,000 individuals, more than 21,000 individuals. A recent effort includes confirming the status of individuals whose certification has expired. These are individuals who were certified by statute, but they may have been active because they were active in July 1 of 2021, but their names were not necessarily submitted for recertification since then. We have untracked them in our records because they may have been part of the original rosters, or they have historical disciplinary information, and we have corroborated that their NPTC ID number is such. So we are in the process of confirming that they were not inadvertently left out of the certification application submissions in the past 3 years, and that they are not retired and working details, which has been the case in some instances. In that instance, retired working details does require that the person be certified, so they need to be within our in good standing within our records. So this confirmation effort also allows us to double check that these individuals are no longer active. So this is also an additional way to corroborate information with agencies. So we will continue to publish the names of officers with which certification has expired, as I have reported in the past. In those cases, it will only be their name and the fact that and the NPTC ID number and the fact that their certification has expired. Now, this slide represents, well, and the next one represent the figures within our records, and is a slight update from a similar slide that I presented last month, and it does incorporate now and going forward all the state level figures. I will note that this chart includes officers currently active and or still assigned to a police department, and it also contains officers who might have left the system, in other words, retired or resigned in good standing since they were last certified, because the certification is prospective 3 years hence. Some officers do retire or move on. Since that certification number, we will still track them as certified for those remaining years. Now, the total number of certified officers is 20,985. We're bordering on 21,000, as I have reported previously. And as a reminder, when we denote somebody who is a certified SRO individual, that individual holds two certifications, the regular certification and the SRO certification, but they only show up once in these charts. That would be the second row or the fourth row. So onto more state metrics. The first two rows of this slide represent a total of 319 individuals and are in some form of review or potentially having a pending matter. The category of not certified on leave may include administrative leave, which may be for a disciplinary matter, or an injury or military leave as well. And when they return, they have 90 days to complete the requirements for certification. Now, the 281 individuals not certified mostly include individuals who attended the Breach Academy and failed, or should have attended the Breach Academy and didn't. As a related category, there are 60 individuals, and that is 56 plus 4, who are in one form of suspension. 56 have been suspended and 4 remain administratively suspended. The figures are updated and reported in our website on a monthly basis, and the names of officers who are within each of these categories will be easily available and searchable in the website given functionality that, again, I will demonstrate at the end of my remarks. Moving on to the Historical Disciplinary Records project, as we have continued publishing and analyzing disciplinary records, we have seen evidence that certain agencies did not resubmit historical disciplinary records when we instructed them to do so at the beginning of last year. We have analyzed records from the first submission as part of our ongoing data quality effort. And we've looked at approximately just north of 1,000 records originally submitted and then not subsequently resubmitted. We believe that approximately 150 records should have been resubmitted, which represents 46 agencies, or an average of about 3 records per agency, but of course that's not necessarily an even distribution. Now, there may be good reasons for why some of these records were not resubmitted, given that these agencies were instructed to omit minor matters from the original resubmission, and to also exclude the records of officers who had retired in good standing prior to July 1 of 2021. Given that these are historical disciplinary records, some of them may be in this latter category. Still, however, we suspect that in some instances, the allowed exclusion of minor matters may have been interpreted too broadly by a few of the agencies that are in this group. So we are targeting records initially submitted that are labeled with a suspension and or appear to have a non-minor matter. And again, we are contacting agencies to ensure that they resubmit that. Now, I do want to stress that not all of these records, the 150, may be publishable. We're contacting agencies to confirm that such is the case, get more background and documentation on those records, and following up on the way that they were originally instructed to do. They are required to resubmit the second template. As we get updates from these agencies, we will incorporate all of those records in the public database on a rolling basis and update as we typically do on a monthly basis. I'll move to hiring. We continue to onboard team members. The most recent hires include Jerry Cahill, who is joining us as counsel, and Penny Walker, who is joining us as paralegal. They both are going to be supporting the General Counsel's office in all of the initiatives and work that they have. These new hires bring the total of post employees to 47, and that excludes a few interns that we had over the summer, the hearing officers and commissioners. So there are 47 employees full-time employees of the commission. We still have pending offers for a fourth enforcement counsel, given that there was a vacancy created when Sean Martinez was promoted to the deputy director position. And we also have a third counsel in the legal division joining us later this week. We had a recent promotion in Aliyah Spring, who is now dealing a lot more directly with the media relations, given a lot of the interest that we have and supporting Cindy Campbell in the communications effort. Moving on to the budget cycle, I want to report that the fiscal and administrative team will be reconciling the final spending for fiscal year 24 as we speak. They will the accounts payable period closes later this month, and they will be bringing you an end of year results in the September commission meeting. We're also in the middle of submitting the spending plans to the Administration and Finance Office, and we will be reviewing those plans with the chair in the coming weeks before we submit them to ANF. Fiscal year 25 hiring forecast will also be presented at the September commission meeting when we update the commission regarding those fiscal year 25 spending plans. And by way of background, the spending plans are essentially an updated budget forecast for the year that has now begun. And this is all necessary given the fact that the budget was first submitted to ANF almost a year ago. The governor, since our last meeting, the governor signed the budget for the state, and it includes fiscal year 25, a figure of 8.75 million for post, as I had reported in a previous meeting. Again, we'll be coming back and submitting those spending plans to ANF in early October. Finally, let me mention as part of this presentation that the new website of the Post Commission is now live. The domain is mapostcommission.gov, and we have already announced and socialized the new website to those stakeholders that follow our news updates. The prior web pages will have a redirect to the new pages, so any user who may have bookmarked a certain page or pages will experience a seamless transition to the new website with its additional new content. As Cindy mentioned in the last commission meeting, when we previewed for you the work that we did to date, it is very easy, a lot easier to upload and update information given the new platform that we are now utilizing. And our plan is, of course, to make it ever more relevant to those who engage with posts by keeping the content up to date and with more and more information as we move forward. I'll highlight something that we also may have mentioned last month, and that is the fact that the new platform enables the communication and technology team to really see and do analytics as to what users are experiencing, where they're going, and how are they interacting with us, which is, again, something really exciting. There is a much easier to use feedback tool, and we hope that our users submit feedback and we can be responsive in real time. But the most exciting part for me and the communications team and others is that there's now new functionality that serves in order to search individual names, agencies, and certification categories. I will demonstrate that in a minute, but I want to mention that this is just the beginning of a significant effort that we have ahead of us in implementing a business intelligence tool that gets us further and further in the mission that's embedded in the statute about having a searchable and publicly available and searchable database for the categories and information regarding officers. So let me, if I may, just transition really quickly to our website, and I'll demonstrate just what I'm talking about. Can everybody see our new website? I just want to very quickly show that when it comes to officer status lists, there is this search function that now agencies can come, the public can come and maybe search for people by police department. All of those, the status of those individuals, their expiration date, and their names will show up. There's other ways to search here. For example, we could search individuals who have been suspended for the state at the state level, and all of those individuals will show here. There's of course the ability to search anybody by last name. We could see who has been or is in our records that fits that last name, where they are, and what their certification status is. I chose Commissioner Ellison to highlight the fact that he was last certified 2 years ago, so his certification is still valid even though he has retired and is now an unassociated officer. So with that, I can conclude my report and take any questions or comments.
Director Enrique, I may have missed it. I like the updated website. I think it looks great. When people are looking up officers and their status, can they see pending cases or our determinations as well?
No, they will not be they will not be able to see pending cases. I only demonstrated a searchable function just now on the status of their certification. We will roll out searchable capabilities for the disciplinary records. We currently have just a PDF, a large PDF, or the ability to download what's called a CSV or an Excel format of everybody that has a disciplinary record. And in those cases, it is typically a record that has been closed. It's not a pending matter. There may be some cases where the discipline is pending, but the matter has been found to be sustained, and we would be showing those cases. But for the most part, any cases, for example, where there is a preliminary inquiry, all of that is confidential as per the statute, so they will not be showing up in any of our databases until the matter is adjudicated.
Okay, thank you.
And I think Deb has a question, Commissioner.
Sorry, Commissioner Holt.
Thank you. Good morning again. So I think the functionality of this database is fantastic, really easier to access information. I'm remembering last month, and this would be my feedback. I believe Commissioner Luma and Bluestone made some comment about representation of that website, the aesthetics of it. It doesn't look very friendly to me as a community member, very blue, very male or male identifying, very law enforcement. And so I think those comments were made. I don't know if that was taken into account because it kind of looks the same to me. Doesn't look like any updates have been made, but I would suggest that it be a little warmer, if that makes sense.
Sure. We'll take that further. We did make some updates in terms of images. You're correct, Commissioner. We did not take a lot of the blue. We can play around with different color schemes and different images. We can socialize them if you would like beforehand. But we did make some of the changes based on some of that feedback. But we'll continue working on that.
Thank you. Any other questions from the commissioners? Enrique, thank you very much for that thorough report. Also, let me thank all the members of the staff who have worked so hard on the matters that you have addressed today. I know I speak for all of the commissioners when I tell you how grateful we are for the work that is being done as expeditiously and carefully as it is being presented to us and to the public through this meeting. And I think with that, we move on to item number 4 on our agenda, namely the election of the treasurer and the secretary. As the commissioners know, since Commissioner Ellison has departed from the commissioner, we have had no treasurer. The position, of course, both that of treasurer and of secretary, takes a lot of time and dedication to it. And I think at this point, I'd like to then take up, first of all, any nomination for the position of treasurer of the commission. Yes, Commissioner Kazarosian, please.
Hi, thank you. I would nominate Charlene Luma as treasurer, if she's willing to serve.
All right. And I think with that, Charlene, would you be willing to serve? Commissioner Luma?
I believe Commissioner Calderon also has a nomination.
Yes, I'm sorry. I'm just
okay.
asking.
Oh, yes.
Thank you. Thank you.
Sorry.
Commissioner Calderon as well has his hand in the air. Yes.
Yeah, I had two pieces. I think Commissioner Kazarosian was the sitting secretary. I don't know if she's stepping down, but if not, I would nominate her to stay if she's interested in staying. My second piece is I would have volunteered for the treasurer's role, but if Commissioner Loomer is willing to do it, then disregard my second piece. But first one stands. I'll nominate Commissioner Kazarosian to stay in that role if she wants to.
Thank you. And I think I did not make it clear that we were going to, first of all, take up the issue of the treasurer. And so that's the issue at the moment. And then in just a second, we'll turn to the question of the election of the secretary. Okay. So I think with that, unless anybody else has any nominations or questions, let me ask for a roll call vote on Commissioner Luma serving as the treasurer of the Post Commission. Commissioner Bluestone?
Yes.
Commissioner Calderon?
Absolutely.
Commissioner Crispin? Commissioner Crispin, you're muted.
A resounding yes.
Commissioner Hall?
Yes.
Commissioner Kazarosian?
Yes.
Commissioner Talley?
Yes.
I'm also affirmative. So congratulations to Commissioner Luma, the new treasurer of the Post Commission. Thank you very much for your willingness to serve. And with that, we move on to, but I think already may be a bit moot, and that's the question of the election of the secretary of the commission. And in response to, I think, the implicit question that you had, Commissioner Calderon, technically under the statute, there should be an annual vote for the election of our secretary and our treasurer. And that's why we are at this time taking up the issue. And with that, do you want to renew your nomination of a minute ago?
Please, if I could, I would move to nominate Commissioner Kazarosian in that role.
And Commissioner Keserosen, are you willing to serve, continue to serve?
Thank you, Commissioner Calderon. Yes, I am.
Thank you. Any additional nominations? I think with that, there being no further nominations, let me ask for a roll call vote. Commissioner Bluestone,
Yes.
Commissioner Calderon did the nomination. Commissioner Crispin, please.
Yes.
Commissioner Hall,
Yes.
Commissioner Luma,
Yes.
Commissioner Talley.
Yes.
And with that, congratulations to our renewed Secretary, Commissioner Keserosen. We are grateful to the two of you for your willingness to serve as officers of the commission. And with that, we move on to the legal update, item number 5 on the agenda. Our general counsel, Randy Ravitz, and counsel Annie Lee, I think, are going to present this.
Thank you very much. We will start with a topic that we've discussed before, which is a set of regulations concerning maintaining, reporting, and auditing of law enforcement records and information. And I will seek to share my screen. Can people see the
Yes.
presentation? Okay, good. Okay, I'll just start with an overview of the regulation development process, how we got where we are and where we might go from here. The initiative began in May of 2023. At the Commission's public meeting, there was an introductory presentation on this general subject. Then later that year, in the November 2023 Commission public meeting, there was a follow-up presentation discussing the process of drafting these regulations. The following month at the Commission's public meeting, there was the introduction of a draft set of regulations, accompanied by a presentation on the key aspects of the draft and the process. Then at the May 2024 Commission public meeting, there was the recirculation of the presentation that had been given in December 2023, and the introduction of a revised draft set of regulations. That was accompanied by another presentation that focused on the changes that had been made and an example of what an audit of a law enforcement agency by the Commission might look like and how it could be used. The commissioners voted unanimously to begin the process of promulgating that revised set of regulations. However, there was an understanding that a revised draft, meaning in the next round, would include procedures for agencies to object or appeal or seek reconsideration regarding the timing, the nature, the procedural aspects, or the outcome of an audit. Then we proceeded to the formal promulgation process. So between June and August of 2024, the Commission published the required notices and sent emails to interested parties seeking public comment. And there was a public hearing on August 1st, at which several people provided verbal comments. And we also received 7 sets of written comments. Then, as you know, there's also, separate from this, another initiative underway, and that's the initiative that my colleague Annie Lee will talk about later, which is the development of agency certification standards. And in connection with that process, we received some additional comments that might have a bearing on these regulations and whether they were the commenters intended for that or not. They provide thoughts that we might want to consider going forward. Now at this meeting, we beforehand circulated to the commissioners all the written comments that we received, as well as a draft of the regulations that were put out for promulgation with summaries of the written comments received, All of that will be published on the commission's website as we ordinarily do with commission meeting packets. And I'm offering this presentation on that same subject. And the goal is to come back in September to the commission's public meeting with a revised set of draft regulations that takes into account the comments that have been offered by members of the public, as well as any others offered from within our own agency, and adjust the language of the regulations accordingly as best as we can, and to present that to the commissioners for their consideration and possibly a vote. And that draft would include language of the type that had been proposed in the May 2024 public meeting. So in other words, you're not seeing that yet, but that's the understanding remains the case that that's something for us to work on. So I'll summarize the larger comments that we received. Under the category of requirements for agencies to maintain records, some commenters would add to those requirements. They would require agencies to maintain records of whether officers received training on certain internal policies, and to maintain records on scores that officers received on examinations and other qualifications. And they would require agencies to use standardized terminology regarding dispositions, such as sustained or not sustained, with respect to disciplinary matters, as well as officers' reasons for leaving employment. There's some language in there that generally would allow the commission to take that step, but there were people who offered more specifics about what that could look like. Other commenters said there are certain things that agencies should not be required to do. And they said, for example, they should not be required to insert a long list of records into individual personnel files, but rather they should be required to insert those records into a separate file. So one commenter described this as, for example, a post-commission file that's separate from the personnel file. And I think really the intent originally was to just make sure that if we or someone else wanted all information regarding an officer, that it would not have to be collected from a lot of scattered places, that there would be one place to go. So this is a different approach to, I think, achieving the same objective. Other commenters said that agencies should not be required to maintain all contracts, or at least that these regulations should not get into that. That they also should not require agencies to maintain all records that had been exchanged with and reports that had been generated by auditors and consultants and the like. That they should not be required to maintain letters of counseling that had been issued to officers. That they should not be required to maintain determinations made by prosecutors that a particular officer has credibility issues and should not be called as a witness or should be flagged as part of disclosures of exculpatory evidence made by the prosecuting office. And other commenters said that these regulations should not require agencies to maintain information on constables within their jurisdiction. That the information that the draft would require them to maintain would be basic information. Who are the constables within their jurisdiction? What is their contact information? What are their terms? But some said not to require that. Then additionally, some commenters said that the regulations should state that they do not require the recreation of records that were lawfully destroyed previously. Some said that they should allow for expungement of records, perhaps after a period of time. Some said they should not require individual officers to maintain records. In fact, there were a few comments along those lines, but one agency that commented liked the idea of the regulations requiring certain records maintenance obligations on the part of individual officers. A thought, by the way, would be to accommodate and respond to some of the comments and the reasons that were offered by instead requiring officers to ensure that that their agency has certain records, and then leaving to the agency the obligation of maintaining them. And yet another option would be to not impose any obligations along these lines on individual officers and let these regulations focus solely on agencies. Other commenters said that the commission should not allow itself in the regulations to add to the list of the records to be maintained. So in other words, a catch-all that was included in there should be cut. Now, within the category of reporting information to the commission, there were fewer comments, but one was that the regulation should not require agencies to report information on criminal matters involving agency members who are not officers. So that was one place in which the regulations said, we'd still like to hear about information of this type related to anyone who's working in the agency who's not a law enforcement officer, if they're involved in a criminal matter, meaning arrested, prosecuted. Another comment is not to require individual officers to provide information regarding the heads of their collective bargaining units. And really the reason that's in there is, well, it's largely because our statute requires us in certain instances to provide notification to the head of a collective bargaining unit if an officer is, let's say, facing suspension. And I would think that the reason that was put in there was to ensure that the officer has the opportunity to get representation by the head of the collective bargaining unit, and similar requirements have been included in our regulations. So that's why it was included here, but some would prefer that it not be included. Another comment is to add more provisions that are intended to protect the privacy of information, security of information, the confidentiality of sensitive information when it is transferred to us. There were comments related to the part of the regulations that dealt with auditing. One comment was to enable others, like members of the public, to request that the commission audit an agency. Another comment was to add qualifications for those who are conducting audits. Again, here too, it's relevant to note that the comment about provisions to protect privacy and security and confidentiality. Another comment was to better define the standards and criteria by which those who are being audited would be evaluated in an audit. And perhaps one way of approaching that, because it's inevitable that the standards set by the commission will evolve over time, perhaps a way to approach that is to provide that law enforcement agencies would be evaluated against standards that have been previously set. So in other words, it's not the case that the commission would go in and evaluate against a standard that it's never discussed before. It would only be something that where there's an existing standard that the agency could reasonably be expected to have complied with. Still others, similar to a comment before, would say the regulation should not provide for auditing of individual officers. They should only focus on agencies. And there were some other topics. One comment was to reconsider the provisions requiring or allowing the commission to require agencies and officers to complete certain attestations. So to attest to the fact that records are complete, or that they're genuine, or that what's contained in them is accurate. And there were a number of legal issues raised about that, about requiring people to make certain statements, particularly if the statements could be incriminating. And there was some language at the beginning of the set of regulations that would say nothing is, or already said nothing is intended to require anyone to waive a privilege that they might have. But this is something that could be revisited, clarified, refined. Another comment was to better define the standards that the commission would apply if it were taking disciplinary action or imposing penalties against someone for violating the regulations. And then another was to require agencies to permit prosecutors to inspect their records so that prosecutors can fulfill their obligations to provide exculpatory information to defendants. There are a number of additional comments that I haven't addressed in this presentation, and that's because some are actually addressed by other provisions of the regulations or by statutory provisions. So in other words, there's already something in there or in the statute that seems responsive to the comment. Others related to things beyond the scope of these regulations. So for example, the standards that would be employed in imposing discipline or in making certification decisions. Some raise issues that can be easily clarified, so don't even, I think, necessarily need to be discussed. And other raise more general considerations, like don't forget that any new requirement will impose additional burdens and will require resources on the part of agencies, and that should always be recalled. It's an important consideration. It's just this presentation focuses on actual textual changes. And then others, as I mentioned, were offered as responses to the request for input on agency certification standards, which is a different process. And looking at them, maybe some of them might warrant some changes to these particular regulations, but a lot of them were of a different nature. They dealt more or less with things that go to the heart of the purposes behind these regulations and more related to other policy matters that maybe we shouldn't try to incorporate here, but should leave for the agency certification process, which is where the commenters offered them. As to any of these additional comments that I said I'm not addressing specifically, I can address them specifically if anyone would like, but otherwise I'm just summarizing them generally. So that concludes the presentation. And if there are any questions or comments that the chair would like me to respond to, I'd be happy to do so.
I think Commissioner Calderon has his hand up.
Thank you, Chair. My question is, what is the intent with the presentation today? Is this open for further discussion? At which point are we going to talk about issues that maybe the commissioners themselves have, or is the intent to have a vote on this today?
No, our intent was really to present the written comments that were received, to summarize them, to hear any feedback from members of the commission, any reactions that could be taken into account in addition to the comments, and then we continue to revise these. I mean, and let me say, by the way, that personally, I think most of these comments are things that we can work with. I mean, there are a lot of comments, so it's a lot of work. It's going to be some time that needs to be spent revising things, but I think generally speaking, these are things that we can work with, and we can do as we've done in the past and try as best as we can to accommodate as many comments as we can.
Thank you for that description, General Counsel. I appreciate that. I wasn't quite sure where we were going, so I'll wait till a further time when we're going to discuss any changes that are taken. I thank everybody who submitted written documentation. I think a lot of the things that were submitted, as you say, if we can accommodate, is a good idea. So I'll reserve any judgment until after a more definitive product comes out. Thank you.
And Commissioner Talley, please.
I had a similar question that Lawrence had asked, but in addition to that, and I don't want to oversimplify it, this contained a lot of information, but it sounded as if the agencies don't want to keep track of a lot of details in the files, which is an override concern. I know we're probably going to discuss this more in detail, but it's when we have our discussions and when information is needed, I think you want as much information as possible, but there seemed to be a slight tone of, well, we don't want to maintain this information in the files or be responsible for it.
If I could just respond to, I think an important policy question for the commission is, excuse me, is going to be, and you can see it in several of the comments, whether to require certain documents to be maintained, even if people would have concerns about how those documents are used. So in other words, determinations by prosecutors' offices, letters of counseling. There are people who say, you know, they can offer reasons why those things should not be taken into account or assigned too much weight in a disciplinary process or in a certification process. But then the policy question becomes, should then the agencies be permitted to not maintain them and to discard them? Or should the rule be, no, they have to still maintain them, and then we'll just decide what weight to give them when the time comes, when somebody is trying to use them in a process or considering that.
Thank you. I think Commissioner Calderon had his hand up, and then Enrique, please.
Thank you, Chair. And Commissioner, I was going to just reply to your concern. I feel the same exact way. Some of this stuff that we're looking at and creating the policy is really and should be geared towards the agency. And that's one of the comments that I'd like to further discuss down the road, is to put the burden on the officer to maintain personnel folders and files on any types of records. That's incredibly burdensome for the officer, and clearly they didn't sign up for a job description that said you maintain files for 32 years of your career. So I like the direction and support the direction where we are as we move forward, but very concerned about putting the onus on the officer. This is an agency requirement. Agency should be responsible for this, but I appreciate the comments too. That's how I feel. Thank you.
And before we go to Enrique and Commissioner Bluestone, Randy, could you take the PowerPoint down so that, is it possible? Thank you. And I'm sorry, Enrique, please, and then
that was going to be my comment, to take down the screen share to be able to see people.
Okay. Commissioner Bluestone, please.
Yeah, I just wanted to say that obviously the goal of making progress and increasing transparency is an important one. But I'm wondering if we know the current status, or sort of generally speaking, the current status of record keeping across the Commonwealth in these departments, and sort of how the new procedures might impact the individual departments going forward.
I think it's something that we're still learning about, and some of the comments were helpful, but I think that there's it would be helpful to go back to some of the commenters. Some of them represented large organizations that have insight into the way that different organizations, different agencies practice. and they concluded their comment letters by offering to work with us. And I think we should take them up on that. And some of it, we're learning through our own experience. So for example, we are seeing differences in terminology that's used. That's just one example, or differences in how quickly we get information from agencies.
Thank you.
Enrique?
That's a very good answer from Randy. I will only add to that the example specifically of the personnel file, which seems to be widely understood as the repository of all disciplinary matters that come in and out and are later considered or not by the agencies. That when it's removed, when letters of counsel, for example, are removed from the personnel file, they're no longer counted in future decisions. Again, that's not, as Randy mentioned, that's not always standardized, but you know, it's out there. There's things like that that's underneath some of these comments.
Thank you. Any other comments at this point? If not, let me move on then to the policy on the use of force. Is that next?
Yes, and I will yield to Counsel Annie Lee.
Thank you very much, Randy, and good morning, Madam Chair and Commissioners. I'm actually going to be talking about really two topics today. So I want to first start with law enforcement agency certification, and then that will lead into a brief sort of discussion about model use of force policy, if I may. And so with that, let me just share my screen. So as you'll recall, during the Commission's June meeting, we reviewed and discussed the process for developing an agency certification program as called for by General Laws Chapter 6E, Section 5A. This is the process that we discussed, and towards the end of the June meeting, we specifically focused on agency certification standards. A quick refresher, Chapter 6E, Section 5B calls for the Commission to certify agencies based on at least 8 topics. Those topics are use of force, reporting of use of force, officer code of conduct, officer response procedures, criminal investigation procedures, juvenile operations, internal affairs, and officer complaint investigation procedures, detainee transportation, and collection and preservation of evidence. However, as we discussed during that June meeting, other agency certification programs in the country uniformly require agencies to meet over 100 standards, generally addressing administration, personnel, training, and operations. Nonprofit organizations like CALEA, the Commission on Accreditation of Law Enforcement Agencies, as well as the Massachusetts Police Accreditation Commission, MPAC, require agencies to meet at a minimum approximately 180 standards. And where an agency is pursuing the highest level of accreditation or certification, 461 standards. Other states that run certification through their post agencies or their equivalent require less, but still over 100 standards. Those states include Delaware, New Hampshire, New York, North Carolina, and Ohio, which require 110 to 116 standards, while Virginia requires 190 standards. And so the question for the Commission at the end of the June meeting was, should the Commission set standards in addition to the statutorily mandated 8? You have a list here on the right of some potential certification topics, and then on the left here, of course, is your 8 statutorily mandated standards. The Commission, during that June meeting, indicated it would consider setting additional standards, but that it would first benefit from hearing from stakeholders before setting any additional standards. So at the Commission's direction, we reached out to a variety of entities and organizations, including law enforcement executives, law enforcement labor unions and interest groups, government executives and offices, legislators, legislative committees and caucuses, as well as nonprofit organizations interested in civil rights and policing reform. As of August 9th, the commission received a number of comments, 19 to be precise, from a variety of individuals, organizations, and entities, including a state senator, the Attorney General's Office Police Accountability Unit, the Civil Service Commission, the Massachusetts Police Accreditation Commission, the Massachusetts Sheriff's Association, the Massachusetts chapter of the National Association of Social Workers, the Civil Rights and Social Justice Council of the Massachusetts Bar Association, Citizens for Juvenile Justice, the Massachusetts Association for Mental Health, Strategies for Youth, the Center for Public Interest Advocacy and Collaboration at Northeastern School of Law, a member of campus law enforcement, as well as numerous private citizens. Those comments generally addressed quite a number of things, as you'll see on your screen here. Some of these comments concern the 8 statutorily mandated standards, which we'll consider in due time. And some of these comments are on matters outside the commission's purview, such as overtime, budgeting, substantive training. And so for the purposes of our discussion today, and the question that's before the commission, what additional standards, if any, should the commission set for agency certification? I want to focus the commission on what I'm going to refer to as in-scope comments. So for the minute, we're going to table comments that address the 8 statutorily mandated standards, as well as comments that are out of scope. And so narrowing it down, these are sort of the list of your in-scope comments. And so what I'll do now is I'll sort of review high level, sort of the general sense of those comments, where they came from, what they're recommending, and then present a recommendation on whether the commission should consider adopting a standard on the topic, or table it for another time. So on the first comment process, we receive comments that can generally be broken down into 2 subcategories, the first of which is development, and the second of which is on comments. On development, there was some apprehension about setting standards in addition to those mandated by statute, at least before those standards are developed and implemented. The Massachusetts Association for Professional Law Enforcement, MAPLE, urged the commission to move incrementally to allow the commission to closely analyze and refine the 8 statutorily mandated standards. The Sheriff's Association suggested that where the creation of the post commission constitutes significant reform, a pause in implementing additional mandates would be preferable, and the commission should focus on assessing and fine-tuning its past work. The Justice Resource Institute suggested that before setting any additional standards, the commission should first assure that the 8 mandatory standards are successfully adopted and implemented across all agencies in the Commonwealth, particularly where setting additional standards would divert resources from essential policing work. And so with respect to these comments, I would recommend that the commission still consider whether additional standards would be beneficial for agency certification. These suggestions to not go beyond the 8 are in the clear minority among the comments received, which tended to agree with the notion that the commissions should set additional standards. And so starting with the first of those additional standards, before I move on, there were also comments on process related to comments. So we received a comment from a private citizen suggesting that the commission should publish on its website all comments received as part of this process to facilitate dialogue between members of the public and commenting entities. And so I want to reiterate at this point what was said during the June meeting, which is we very much want this to be an inclusive process. And to that end, we welcome the input of any and all parties and organizations, law enforcement and civilian. And so there is certainly no intent to sort of stymie any conversation between members of the public, law enforcement and civilian. And so we very much encourage interested parties, law enforcement otherwise, to continue submitting comments to the commission, which will be considered and potentially discussed at a future meeting. And so turning to additional standards, on bias-free policing, the Attorney General's office through the Police Accountability Unit encouraged the commission to adopt a separate standard related to bias-free policing. I think part of this comment is worth reading sort of in its entire reading here for the commission. That part of the comment that I want to highlight for the commission says, The legislature, both in the 2020 Police Reform Act that established the Post Commission and elsewhere, has consistently emphasized the importance of ensuring that system-wide policing practices are free of racial and other biases that harm communities and impair public trust in law enforcement. The Supreme Judicial Court has similarly raised systemic concerns about racial profiling, implicit or unconscious bias, and related law enforcement practices. The AGO, meaning the Attorney General's office, shares these concerns, especially where recent studies have shown that racial disparities persist in Massachusetts law enforcement practices and outcomes, which could be caused, at least in part, by profiling and bias. LEA certification standards would help address this concern by ensuring that police departments take some steps, including, for example, through the development of training programs and implementation of appropriate policies and procedures to mitigate it. An LEA standard focused on bias-free policing could also address the specific role that implicit or unconscious bias plays in disparate outcomes and how it serves as a major barrier to bias-free policing. And so my recommendation here is that the Commission does adopt a separate standard relating to bias-free policing. As the Attorney General points out, one of the legislature's priorities in passing the Commission's Enabling Act was to combat bias in policing, as evidenced by the ban on racial profiling, and also language in Chapter 6E empowering the Commission to refer to the Attorney General's office patterns and practices of racial profiling and other bias by agencies. The next comment refers to equipment. We received a couple comments suggesting that agencies would benefit from having some amount of equipment, particularly for the use of force, such as firearms, baton and impact tools, pepper spray and mace, and handcuffs. And that in turn, the public would benefit from knowing what tools law enforcement bring with them when they respond to a scene. One commenter specifically called for the Commission to set a minimum standard requiring all agencies, including agencies on law enforcement campuses, on higher education campuses, as well as hospitals, to provide all officers with handguns. And so the recommendation here is not to adopt this standard at this moment. I think this, at this moment, if the Commission were to adopt the standard, as the potential to create an unfunded mandate, depending on what equipment is required by standards, and also depending on the particular budget of a given agency. There may be some agencies that just don't have the budget right now to go out and buy certain equipment or to update certain equipment. And so moving on to the next comment, I'm going to group these together: processing and temporary detention, as well as holding facility. We received a comment from the Massachusetts Police Accreditation Commission, MPAC, which described these two standards as critical because while they are low risk, so generally you're not going to have many incidents related to processing and temporary detention, as well as holding facility. When there are incidents, they're high liability. And so the recommendation for the Commission here is to adopt a standard on these two topics. The current standards required by statute call for the Commission to set standards on prisoner transportation. Processing and temporary detention and holding facility are closely related to that topic. So there's an alignment between what the statute already requires and these additional standards. And then on legal process, which is the next comment, this is again another standard that the MPAC identified as low risk, high liability. The recommendation here would be to adopt such a standard, but as part of a compliance with a constitutional requirement standard, which is a standard required as part of CALEA accreditation. And so the reason I suggest here that it would be beneficial as part of a compliance with constitutional requirement standard is that there are legal rights that kick in sort of even before a formal legal process has been started. So there are rights concerning constitutional rights concerning search and seizure, on interrogations, on Miranda rights. And so I think that, to limit this to legal process wouldn't quite sort of address kind of the larger concern here, which is, again, low risk, high liability. So on the next comment, which relates to conflict of interest, we received a couple of comments, one from a state senator and one from a private citizen, suggesting that the Commission should set a conflict of interest standard. This arose from an incident in Braintree in which it's alleged that Braintree command staff violated conflict of interest laws during an investigation, which ultimately resulted in Braintree adopting a conflict of interest policy. And the recommendation here is to adopt this conflict of interest standard, at least as part of the criminal investigation procedure standard, given that the specific incident here occurred during a criminal investigation. However, I think it's also worth considering whether to adopt a standard on conflict of interest that stands alone. And so that standard could define a conflict of interest, prohibit conflicts of interest, set standards for managing those conflicts, create a process by which others can, quote unquote, whistleblow on those conflicts, set consequences for violating conflicts that could include investigation, potentially decertification. Part of this, part of what I described could be part of an IA standard, but this is a complicated issue that may warrant its own standard, both for clarity and to convey the importance of managing conflicts. And so the next comment I have is on data collection, analysis, and reporting. This is a subject on which the commission received numerous comments on. It was actually the most popular topic among commenters. These comments highlighted that there's a dearth of data on what law enforcement is doing, which makes it difficult to understand how law enforcement is functioning and its effect on the public. And so, for example, we received comments on use of force, pointing out that use of force incidents are only required to be reported when it results in death or a serious bodily injury, or when an officer discharges a firearm at or in the direction of a person. That comment pointed out that these kinds of incidents are at the extreme end of the spectrum and do not include minor use of force or use of non-lethal weapons and devices. There was also a comment pointing out that there's a lack of data on how many calls for service are calls about behavioral or mental health crises. And so this comment suggested that agencies should report data on how many calls for service are related to behavioral and mental health and not criminal activity and the outcome of responding. And so there was also comments on traffic stops as it relates to bias-free policing. One commenter noted that in their community, over half of traffic stops result in verbal warnings, which are not currently recorded, and that to better understand who is getting stopped and the outcome of the stop, agencies should collect data on all officer-initiated traffic stops, not just those that result in a citation. And there was also another comment on collecting data about engagement with juveniles and youth. The thorough line of these comments is that data is essential to understanding inequities. And furthermore, as the Attorney General Office wrote, data maintenance and retention standards would further a sense of confidence, consistency, and reliability in government handling of potentially sensitive information. And data transparency standards would make clear that Massachusetts police departments have nothing to hide, thereby increasing public trust in law enforcement while protecting people's right to understand how they are being policed. Moreover, setting workable standards in each of these areas would serve the interests of good government and effective law enforcement practices, especially given the importance of access to comprehensive, reliable data and identifying agency patterns, practices, and systemic issues that require reform or remedial action. This is one critical reason the issues of data integrity and bias-free policing are, to some degree, inextricably linked. Patterns of bias cannot be uncovered and addressed without adequate access to reliable data on law enforcement practices. And so the recommendation here is to adopt a standard. I would recommend that a data collection, analysis, and reporting standard also be adopted in conjunction with a planning and research standard. One of the critical results of data collection, analysis, and reporting is being able to objectively evaluate if identified goals and objectives are being met, and if not, changing policies and practices to better meet those goals and objectives. And then the next comment received relates to personnel. There's a comment from the Civil Service Commission that agencies have an obligation to report to the Human Resources Department of the state their list of civil service appointees employed by that agency. The comment described an example of where this obligation was not followed, and it stymied the development of a diverse police force in Methuen. And so the recommendation here is to adopt a standard, but in a separate compliance standard We've heard in past meetings of this commission from the executive director that there are some agencies that are not yet in compliance with post obligations. It would be helpful to stress the importance of complying with all legal and regulatory obligations, including those of posts and HRDs in a separate compliance standard. The next comment relates to community engagement and communication. Many comments stress the importance of dialogue between an agency and the community it served. There were comments that expressed hope that the community would be able to collaborate with its agency, whether through community meetings or case conferences or something similar to what we're doing here and soliciting public comment. And so my recommendation here would be to adopt such a standard. Many comments came from a sense of feeling out of the loop or like agencies aren't quite understanding the lived experiences of members in their community. I think such a standard would go a ways to furthering trust and reliability, as emphasized by the Attorney General's office. And lastly, the last in-scope comment we received pertained to agency wellness. Many comments raise concerns about whether officers have sufficient resources within an agency to cope with the stress and trauma they experience as law enforcement officers. This is a topic the Commission has itself expressed concern about in the context of agency wellness supporting officers' ability to maintain good moral character and fitness for employment. And so I'd recommend adopting such a standard. There's a consensus that we want officers to succeed, and to the extent there are agency resources available to officers that support them in doing their jobs well, a standard requiring the agency to make its officers aware of those resources could be helpful. And so that sums up the comments that we received here. And returning to the first set of comments that we reviewed, those suggesting that the Commission shouldn't set any additional standards. If the Commission is inclined to prioritize the 8 statutorily mandated standards, I would suggest that the Commission still consider adopting 3 additional standards: one on bias-free policing, one on data collection, analysis, and reporting, which would encapsulate research and planning, and a third one on community engagement and communication. So at this time, I'll take down my slides, and I'd be happy to answer any questions from the commissioners if the chair would like me to.
Perhaps we can start with Commissioner Luma. I'm not sure who first had his or her hand in the air.
I think it was Commissioner Hall, then Calderon.
Okay. Commissioner Hall, please.
Thank you, Commissioner Luma and Chair. Of course, I'm interested in us adopting additional standards. And I think the ones that were listed in the information we received back is great. I would like to, I don't know if we can still add anti-sexual harassment to that list, just because of the number of cases we review that include that. I think it's really important for us to take a look at that. So I'd like to put a pin in that.
Noted. Thank you very much.
And I'm sorry, again, I'm not sure who was next. So Commissioner Crispin, please.
Yes, good morning again. One of the things I'd like to see is take a deeper dive on is bias-free policing. While there are standards in place now, they're just generally not rigorous enough. They generally take place at the academy level, maybe an in-service, but we're not really doing a deep dive and looking at this. This has been a historic issue in policing. I just don't think there's enough work that's been done on it, and the departments don't seem to be very invested in working on those issues.
Thank you, Commissioner Calderon.
Thank you, Chair. If I could, Annie, could I ask you to resend those comments that you were reading on all these topics? Would you send them so that I can take another peek at them?
Yes, we can do that. I believe that they were sent out in a folder because they're quite large when comprised together. But if possible, Jamie, if you're able to resend that, that would be incredibly helpful. I can also do so after the meeting.
When was that sent to us?
It was sent yesterday.
Okay, and
Yeah.
again, I'm sorry.
I may have it then, Chair. I apologize. I thought it was sent some time ago, and I just wanted to save myself from trying to find it. But if it was sent yesterday, I'll check right now.
And I'm sorry, I'm just a little confused here. So, Annie, all of the comments were sent to us. Is that it?
Correct.
Okay, and again, I'm afraid I also missed that, so if it could be resent, I'd appreciate that. Jamie, and Commissioner Luma, please.
Yes, so thank you for just putting this together. And I understand the concern of kind of wanting to address the 8 that we currently have before moving forward. But I do agree with you as far as the standards that you did identify. I did have a question in regards to the conflict of interest. And this is just because I may not know, how does the request differ from what the mandate is as far as conflict of interest from the state that's required for public employees?
Right, so it doesn't specifically, it doesn't differ in substance from it. So the allegations there are that the department violated the state conflict of interest law. But I think what was also part of the comment is that there was no disciplinary action taken either at the agency level or by post because the agency didn't have a conflict of interest law, right? So the officer could say, or at least in the investigation, the conclusion was that there was no violation of agency policy simply because there was no agency policy in place. And so I think that the comment here is to have an agency level conflict of interest policy, with the idea being that this can be the basis for an internal affairs investigation and for potential discipline by post or by the agency itself.
So are you saying the current law as it stands does not apply to agencies as a whole, but just individuals?
I believe that's correct. So that there's an individual obligation to abide by certain ethics and standards, but there is not sort of an agency policy that says, here's how we manage conflicts of interest. And so one of the specific issues that this comment raised is that the conflict of interest sort of went up to some of the highest levels of command staff, and there wasn't a policy in place calling for the conflict or for the investigation to be managed either by another agency or by an external investigator here. And so I think that the suggestion here is that there should be a comment that sort of addresses it beyond sort of saying that, you know, conflicts of interest are prohibited and, you know, this specific officer with a conflict can't do it. Saying that if that agency can't adequately manage it, as procedures in place or standards in place to make sure that the investigation is still conducted by someone who is who doesn't have a skin in the game or doesn't have some sort of interest.
Yeah, I mean, you know, after the 3 that you've already identified, I would think that would be a priority, particularly when there's expectations with command staff and supervisors to report certain things. I would want to make sure that that was in place.
Thank you. Commissioner Bluestone.
Yeah, I thank you so much for the presentation, and the recommendations I think sound really strong and reasonable. I think that we are trying to balance the goals of elevating the standards and increasing the professional tone of law enforcement with the reality of how standards may impact the different departments and agencies and how quickly we can move forward with this progress. But if we are considering adding additional standards, I would argue strongly for including a standard on wellness. And the reason being is that as we have heard, you know, about circumstances across the state where there have been problematic responses by law enforcement officers, one of the primary factors in those circumstances is the impact of alcohol and substance use, as well as work-related stress on the functioning of law enforcement professionals, and the associated symptoms of just the anger, the fear, and the negativity that can go along with that form of coping with stress. And the wellness piece, in my view, really underlies all of the other issues that we're concerned about. And I would strongly recommend that we put that at the forefront if we're adding additional standards.
Commissioner Bluestone, just a question for clarification. Is this a standard relating to officer wellness or to agency wellness?
I think that those two ideas are connected. Both agency and officer wellness are related. I think often I hear from officers that they are concerned about the lack of support that they get from the agency level in terms of resources and time off and the ability to take care of themselves and their families. So I think it starts probably at the agency level, but I also think that standards that encourage officers to take care of themselves would be helpful.
Thank you.
Commissioner Crispin? Sorry, Commissioner Crispin?
Yeah, so I just to follow up just real quickly, just one of the things I think we probably should look at as a commission, issues of equity and discipline. This has been a problem in law enforcement for years. We've heard from a number of officers from agencies across the state around lack of equity and discipline, especially from officers of color. Then just one other thing that we may want to address is specifically around equipment. I know there was some mention made around equipment. For years, we've heard about the impact of belts, the duty belts police officers wear around their waist. And I know personally, I know of at least 15, 20 different officers who have had hip replacements. While there's been a lot of concern about the appearance of military appearance of having upper body carriers, I think there's some substantial health benefits. That may be something that we want to look at if we're going to look at the how equipment is used across the state with different police departments.
Thank you, Commissioner Kazarosian.
Yes, thank you. This was a lot of information. Thank you so much for putting it together. It's a lot to digest. And my head is spinning, even though I did have a chance to review some of the comments before, but it just doesn't seem like it's enough time. And there's a lot to do. I'm wondering if it's worth considering doing this like incrementally instead of all at once, and maybe take the required ones plus some other key areas and in a first round, and then go for a second round and attack the other ones, because it just seems like they're each, even just the required ones, take a lot of concentration and are going to have a lot of input and comment. So my suggestion is just that we try to approach this incrementally instead of one big chunk.
Commissioner Kazarosian, I was going to sort of discuss the process of how we're going to approach the 8 mandatory standards shortly. And so,
all right, sorry.
No, that's okay. I'm happy to sort of get ahead of it now, which is to say that recognizing that the 8 encapsulate a lot of important things and require a lot of time and care. My suggested approach was to essentially do it standard by standard. So, after we wrap up this discussion, I was going to move to sort of discussing a use of force standard or a potential use of force standard. And then the idea would be at a future meeting to do code of conduct, at another meeting, do officer response procedures and complaint investigation procedures, to essentially spend like one meeting essentially per standard, and to essentially build certification brick by brick, spending time looking at each standard sort of comprehensively, making sure that there's opportunity to digest all the information that you're getting, and to also make considerations about whether there need to be revisions, to also allow time to consult with MPTC as required by statute and other stakeholders. And so when sort of discussing these other additional standards, my intent here wasn't to sort of say, okay, like I will come back to you next month with standards on bias-free policing, on anti-sexual harassment, on conflict of interest, on data reporting, et cetera. It was just to get a sense of what additional standards, if any, the commission would like to set, and then return to sort of those substantively after the 8 have been sort of developed.
Okay, so the first 8's the priority then, is what we're going to start with the first 8. Okay, I understand that. Great. Thank you.
Mm-hmm. And just to add to that, I'm hoping that maybe, we kind of go beyond what you just described and prioritize which ones we're going to focus on and create some form of outline. I think even doing it month to month is challenging because typically we get, we get a draft and then there's discussion and then we come back and come back again. So I think we need like a really firm outline or timeline and then determine how we're going to prioritize even the 8 that we have.
I can certainly prepare that for the next meeting.
Thank you. Any other questions or comments? And let me also thank you, Annie, for the depth of your presentation. And I think you've already made reference to the fact that you're prepared today to address the use of force issue, and maybe you can just sort of efficiently address that because we have a number of other matters to take up.
Yes, absolutely. The good news is it'll get quicker from here. So, in the interest of keeping things moving, let me just share my screen again. And so, all right, so turning back to the 8 statutorily mandated standards, the 8 is on your screen. Like I said, I wanted to discuss a standard relating to use of force and reporting of use of force today. But first, I wanted to just sort of speak to process. And so, as I said just 2 minutes ago, many of these standards are very broad. And so my plan is, rather than to sort of overwhelm you with draft language on all 8 standards all at once, is to present standards topic by topic to the commission for its consideration. The hope being that after the commission has reviewed each standard in depth, at the end, you'll have all of the certification standards ready for promulgation. I plan to use this same process for each section of the regulation. So after standards, we do a discussion on compliance and assessment, then maintaining compliance, so on, so on. And so, to make things more manageable along the way, I'll plan to ask for votes to include a proposed section in the regulation, not today though. And at the end, the commission will vote to promulgate the regulation after all sections from standards to sanctions have been discussed and approved by the commission. At any time prior to this vote, the commission has the ability to return to any part of the regulation for discussion and revisions. And the same is true following final adoption, the difference being that there will already be regulations that are effective, and revisions will have to be made through the promulgation process with the Secretary of State. So just really wanted to stress that there is a lot of process going in on this, and we're doing this carefully, going brick by brick, as I said, but also, to Commissioner Luma's point, trying to do so efficiently. And so today I want to discuss use of force. I'll note for the commission that this is different from a model use of force policy, which I'll discuss shortly. They're related, of course, because they're on the same subject matter, but they're 2 separate items. I want to stress today that what was included in your packet is not final, and we're not asking for a vote for inclusion in a future regulation. It's meant to be a tool to sort of illustrate to the commission what a potential use of force standard may look like. And so in drafting the standard that's in your packet, my approach was to take what's already on the books, meaning the commission's statute, regulations, and guidance, and further flesh it out and supplement that substance with best practices gathered by researchers, government executives, and practitioners. So on your screen, you'll see a list of resources. This list of resources consulted is not an exhaustive list, rather illustrates some of the key resources that support some of the concepts you'll see in the draft standard. And so putting it all together, the current law, regulations, and guidance with the best practices identified by researchers, government offices, as well as practitioners, it became apparent that there are elements that are critical to the use of force, which are the list that you see on your screen here. And so I'll review these elements at a higher level today, but the document in your packet can be considered an example of potential language the commission may be interested in adopting in the future. I'll note again, because this is, a brick by brick process, it's the language in your packet is only with respect to use of force standard and a reporting standard, as well as definitions pertinent to those standards. It doesn't include anything on compliance, assessment, etc. It also doesn't include other definitions that will be relevant to other standards and sections of a future agency certification regulation. And so turning to sort of the draft use of force standard, the elements that I identified, the first one was key principles. So it's important to state at the outset sort of the values of a use of force principle. And some of the ones that are illustrated in your packet include dignity and respect, as well as fair and unbiased policing, speaking to the comments that Commissioner Crispin made. The second element is de-escalation. This is the other side of the use of force coin. The Commission's use of force regulations at CMR 6.04 and 05 required de-escalation tactics to be attempted or to be infeasible prior to using force, but beyond a definition of de-escalation tactics, it's not otherwise addressed. I think a specific standard on de-escalation reminds agencies and officers not only of the de-escalation tools and resources they have, but it also foregrounds the importance of prioritizing de-escalation at all available opportunities, even when force is likely to be used or is already being used. It reminds agencies and officers that the priority is always to safely resolve an encounter without further jeopardizing the safety of members of the public or law enforcement. I would also further suggest that a de-escalation standard would be consistent with the spirit of CMR 6.04.2, which requires officers to use de-escalation tactics, quote, where feasible. So the next section or the next element of a draft use of force standard would be to authorize the use of force. And it sets forth two requirements for the use of force, the first of which is attempting de-escalation or de-escalation is infeasible. And the second is that no effective, safe, or feasible alternative appears to exist. This would be consistent with, again, 604 and 605, which authorize the use of force only when, quote, de-escalation tactics have been attempted and failed or are not feasible based on the totality of the circumstances, end quote. And then after that, authorizing use of force, setting specific and comprehensive requirements for the use of non-deadly and deadly force consistent with 604 and 605. After that, there is a slightly new section on use of force devices. And so turning to CMR 6, firearms are mentioned in the context of shooting into or at a moving motor vehicle, and tear gas, chemical weapons, kinetic impact devices, rubber pellets and bullets, electronic control weapons and devices, and dogs are mentioned in the context of mass demonstrations and crowd management, but devices for the general use of force are not otherwise addressed. The comments on equipment demonstrate that standards for devices are important not just in mass demonstrations and crowd management, but also in use of force as a general matter. I think to be more specific and comprehensive, the Commission would benefit from setting a sub-policy that requires departments to have use of force device policies for each device available to officers for the application of force. The next section would be a section on mass demonstrations and crowd management consistent with CMR 608. The following section would be prohibitions against excessive force that would be consistent with CMR 602 in the use of non-deadly force and CMR 605 in the use of deadly force. And CMR 606, which calls for an officer present and observing another officer using excessive force to intervene. This section would essentially emphasize that prohibition on excessive force. And then the following section would be a duty to intervene, consistent with CMR 606. The next section, a duty to render medical aid, consistent with CMR 604 and 605. And then the following section would be on-duty debriefings and reviews and trainings. Those are the last sections. And so the idea here is to ingrain de-escalation priorities and the proper use of force, not only through the training that officers go through when they're recruited and annually during in-service training, but to reinforce that training in the field. I think these post-incident debriefings and de-escalation reviews don't have to be anything too formal. They can be short, but the point is to encourage officers to think about what worked and what could have been done better, to essentially be doing that as they're on an ongoing basis, that not only helps them sort of refine their own practices, but also the officers that they're doing this exercise with. And so that concludes my presentation of sort of the elements of a draft use of force standard. I want to say that I recognize that the document in your packet is specific and comprehensive, but from my conversations with the MPTC, I understand that this is consistent with what's being taught. When we spoke, they said none of this was new. They said, they went through the standard, they say, yeah, we're already doing this, we're already doing this, we're already doing this. So this standard that's in your packet is a matter of sort of spelling things out and making it clear that these are the minimum standards with respect to use of force. I don't believe that this really does change the landscape of use of force. Just makes expectations clear.
Thank you.
Yep. All right.
So maybe, can you remove the PowerPoint?
I can, yes. If there are any questions, I'm happy to take them.
And again, let me thank you for the thoroughness of your presentation. I think you've given us a lot to consider and think about, and we will obviously continue addressing these issues at our monthly meetings. Unless there are any additional questions or comments, and I don't see any hands in the air, I think this moves us on to item number 6 on the agenda, and we turn now to LaRonica with regard to what is defined as policy discussion.
Thank you, Madam Chair. I'm sorry. I see my colleague.
Sorry, LaRonica. I'm apologize, Chair, but I do have 2 more items to quickly review, one of which is elements of a use of force reporting standard, as well as a quick presentation on a model use of force policy. I'm happy to bring that back at a later time. I know that we're pressed for time, but if you can spare me 10, 15 minutes, I can walk quickly through it.
And I think, given the fact that what else we have to address today, I'm going to suggest that we move on at this point, given the hour, and we'll address that at the next meeting. Thank you very much again for your presentation.
Thank you.
Okay, good morning again, Commissioners. I have 3 policies to present to you today for your consideration and a vote. The first policy we have to address concerns the prohibition of weapons in commission offices and designated facilities. The commission voted on September 14th of last year to make the current policy effective. And I will share my screen so that I can expedite this process. Okay, I believe I'm effectively sharing my screen now. In essence, the current policy prohibits weapons such as everything from firearms to blunt objects, chemical sprays, and any other item the commission deems dangerous and likely to present a threat to safety and security of the building or its occupants. It's important to note that the policy, as it currently exists and as it would exist upon your vote, does not apply to law enforcement officers serving as commissioners, of which we have 3. Anyone with a weapon attending a commission event needs to store that weapon off premises, or they will be denied admission to the commission event. This includes subcommittee meetings or meetings that are held here at the at our headquarters. The highlighted language is what the revisions to the policy would consist of. They primarily grant the executive director or designee the ability to authorize the possession of weapons. The remaining content of the current policy is unchanged. Upon your vote, this policy would supersede the current policy and become effective. Madam Chair, I am open to any questions on this, and then would ask that there be a vote.
Commissioner Bluestone.
I would just raise the point that if there's been authorization of a weapon to be brought into the facility, that would be disclosed to the participants of any meeting or who were in that environment.
Just so I can clarify and make sure that I know your message here, Commissioner Bluestone, when you say disclosed, in what manner are you suggesting?
I would just, I mean, I don't know whether this should be part of the policy, but just as a matter of course, I think that any attendee at a meeting where this policy is in place should be informed if there is a weapon being brought into the facility.
And it's my understanding that you're stating that this could be a practice that the executive director executes.
That if the executive director or his or her designee gives permission for a weapon to be brought into the facility, that be disclosed to the attendees of any meeting.
We can incorporate that change, Commissioner.
Commissioner Crispin.
I don't know that I got a thorough look at the policy. I'm just thinking about those of us who are in law enforcement and those of us who may be coming in during work hours while we're working, how that would impact us. Would there be an exception? How does that
So,
work out?
For you, Commissioner,
Does not,
in
okay,
the
I see it,
current-
never mind.
current
Never
policy
mind, I'm
as well,
sorry.
okay. It's actually the last sentence in the first paragraph.
Sorry about that.
Commissioner Talley, please.
It wasn't mentioned, but maybe it's implied that, is there going to be a checkpoint to reinforce this policy?
Commissioner Talley, that's good. That's a very good point. I think it's implied.
Okay.
Enrique.
I was just going to comment that with these changes, the likelihood that this would apply to is essentially chiefs that come in uniform from time to time to some of these meetings and are not currently included in the policy. I just wanted to put that background in there.
And I think with that, LaRonica, are you prepared for us to take a vote? You're asking for a vote, correct?
I am, and it's my understanding that the current policy would include the addition of disclosure to attendees of those who have been approved to carry weapons.
All right, so let me then ask for a vote. Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes.
Commissioner Crispin,
Yes.
thank you. Commissioner Hall,
Yes.
Commissioner Keserosian,
Yes.
Commissioner Luma,
Yes.
Commissioner Talley, Commissioner Talley,
Oh, I said yes.
and I'm also affirmative, so that's unanimously carried. Moving on, next, please, LaRonica, policy for appointment of hearing officers.
Thank you, Madam Chair, and thank you, Commissioners. The next policy addresses the chair's authority to appoint hearing officers in adjudicatory proceedings involving the denial, revocation, or suspension of law enforcement certification. And to expedite things, I will share my screen. In December of 2022, the Commission authorized the chair to utilize the service of retired Massachusetts judges in adjudicatory proceedings until the Commission voted to establish a policy. The chair's authority to make such appointments resides primarily in a regulation that is 555 CMR 110. It provides that in the chair's discretion, those types of adjudicatory hearings may be heard in the first instance by a presiding officer selected pursuant to a policy established by the Commission. Now you're being presented with the proposed policy. It will go into effect immediately upon the vote by the Commission. I'd like to highlight that the Commission has benefited from the retired judges serving in this capacity. They collect, admit, and weigh the evidence that forms the basis of the factual findings. These findings are ultimately considered by you when you make your decisions and make your final decisions. It's also important that I note to you that the ultimate authority to make an independent final determination of all issues continues to reside with the commission. When we look at the policy in general, you'll see in the second section that the chair has the authority to appoint and remove the hearing officer. As we look at the third section, we have the general terms of appointment. They put the onus on the hearing officer to comply with the conflict of interest and financial disclosure laws. There is also a requirement that they engage in the ethical, they get advice from the State Ethics Commission when necessary. They're to attend programs developed or recommended by the General Counsel. They're to draft the initial decisions that come before the commission for a final decision and communicate with the hearings administrator. Madam Chair, I am willing to entertain any questions that the commissioners may have on the hearing officer policy.
Commissioner Keserosian.
Hi, thank you. I think this is a great policy, and I know that we've tremendously benefited from having retired Superior Court judges hearing these, presiding over these hearings, because there are Chapter 30A implications from any agency decision, and it's a very nuanced and not an easy situation to preside over. And I think the experience of Superior Court judges is very, very important here, and it protects everyone. My only suggestion would be to hone it a little bit, instead of just leaving it to a retired Massachusetts judge. I would suggest it would be a retired Massachusetts Superior Court judge. It's sort of consistent with even the statute that has the requirement for our chair, which is a retired Massachusetts Superior Court judge. Superior Court judges are uniquely experienced in hearings that involve 30A issues. There are many other supposedly trial court judges that don't have the same kinds of experience. Doesn't mean that they're any lesser judges, but they don't have the same 30A experience. For example, perhaps a housing court judge or a probate and family court judge. They don't necessarily handle the agency hearings and decisions the way a Superior Court judge would. So I would ask that this have a change that would add retired as a Massachusetts Superior Court judge. I think it protects everybody.
Thank you. Charlene, Commissioner Luma, please.
Yes. Do we have anything in there that specifically says how many retired judges we can appoint at one time, or how many would be on our, I guess, for lack of a better word, staff at one time?
We do not, Commissioner Luma. The chair, within her discretion, has the authority to appoint, and we constantly stay in frequent contact with her on the caseload to engage in case management, but there is not a specific number.
Right. I'm just wondering for a number of reasons. One, obviously it states how many commissioners we can have on this commission. I'm wondering, as we think about moving forward in the future and capacity and our budget, should we define how many we should have available? It's just a question.
I would speak in opposition to that. Commissioner, I think that what we need to do is to monitor the extent of our workload. We have retired Superior Court judges who have indicated an interest in becoming hearing officers. We have an onboarding procedure to implement, but I think that it at this time would not warrant placing that into this particular policy that we would adopt at this point. We can take it up if necessary, but it just, I don't think, has become any kind of issue in terms of overwork or anything of that sort at this point. Okay. Commissioner Luma, please. Or, I'm sorry, Commissioner Bluestone, please.
Thanks. I actually think that this has worked out extremely well, and have been very impressed with the decisions that that we've been receiving. I wondered initially, and I still wonder though, if restricting this to retired Superior Court judges, although I understand the rationale, may limit the representation of diversity among that group of individuals. And that's just a question I would ask you to consider as we move forward with this.
Let me just respond that it seems to me that the issue of diversity is something that, we are always concerned with as we talk about any type of employment or utilization of individuals. And I think it is an overarching principle of post. And I think we are mindful of that as we consider the issue. So I think unless there are any other questions or comments, what I'd like to do is to ask for, I'm sorry, LaRonica, please.
If I may, Madam Chair, I'd like to make a clarification or add something to what Commissioner Kazarosian asked. With regard to the Superior Court judge, I understand what you're stating. I would like to bring forth, though, that we have someone who has served in both capacities as a Superior Court judge and a justice on the Supreme Judicial Court. So I would like for you all to consider if we include language that they have served in the capacity of a Superior Court judge, because we often have judges who are elevated to other positions on the bench. So I wouldn't want to just restrict it to someone who retired as a Superior Court judge.
I agree. I didn't even think of that. So thank you.
Commissioner Calderon, please.
Yeah, if I could just ask at the end of this, can we just affirm what the language is that we're voting on, Madam Chair?
On this particular point raised by Commissioner Kazarosian, is that what you're asking?
That is correct, yes. Are we adding that language, and are you okay with that language? That's both my questions, actually.
Okay. So
So if I may, is it possible that under 2A, we appoint a hearing officer who has served as who has retired and served as a Massachusetts Superior Court judge? Would that address?
I think it's got to go under the one as well. Approves the chair appointing a hearing officer who has retired as I think it's got to go there first.
a retired judge who has previously served as a Superior Court judge, doesn't that do it? A retired judge who has previously served, the judge could have been an appeals court and or an SJC justice. But LaRonica, does that address the issue?
I believe it does, and we'll make the change in both places. In the introductory paragraph on authorization and effect, and 2A to clarify.
Thank you. And Commissioner Calderon, does that address your issue?
Yes, Madam Chair, I appreciate that. I just want to make sure it was consistent with what you were looking to do so far. I think what we've done to this point with the retired judges has worked very well. So I'm relying on your expertise where we move forward here. I think it's a good thing to do.
Thank you. Are there any other comments or questions? If not, let me ask for a vote. Commissioner Bluestone, please.
Yes.
Mr. Calderon.
Yes, sorry.
All right. Commissioner Crispin.
Yes.
Mr. Hall.
Yes.
Mr. Kazarosian.
Yes.
Shaluma.
Yes.
Mr. Talley.
Yes.
I'm also affirmative. That's unanimously carried. And then lastly, LaRonica, the policy for the appointment of single commissioners.
Thank you, Madam Chair. My final policy concerns the appointment and the authority of the chair to appoint a single commissioner to serve in proceedings that involve requests to stay suspensions. These suspensions are imposed pursuant to two regulations. One is 555 CMR 1.06. That's when someone is suspended pending a preliminary inquiry. And the second provision is 555 CMR 1.08. That is when someone is suspended following an arrest, criminal charge, or indictment for a felony, or following a preliminary inquiry. And if I may share my screen, I think it might expedite things. Okay, it won't if I share that one because that is not the correct document. Okay, I believe I have the correct one up now. In
Yes.
proceedings involving the single commissioner, that decision is final as to the single commissioner. The proposed policy sets forth the chair's ability to make the appointment, and the single commissioner can come from either of you. The appointment can be any of our active commissioners. When we look to the policy, we see the authority and duties of the chair. Once again, she has the ability to appoint or remove the single commissioner. Matters before single commissioners are adjudicatory proceedings. They're subject to Chapter 30A, and therefore they include the associated rules of evidence, burdens of proof, legal procedures, and other legal obligations. When we look at the terms of the appointment, it's essential that we include that commissioners serving in this capacity be provided with some guidance beforehand and possibly during the process. Therefore, we have outlined some mandatory and discretionary terms that would assist the single commissioner with the legal substance of their statutory role. Under the general terms of appointment for the single commissioner, there's a recommendation that the single commissioner participate in programs developed and approved by the general counsel. Please note, there is also a requirement that the single commissioner, prior to appointment, attend programs developed, administered, or recommended by the general counsel to provide guidance on conducting these adjudicatory hearings. Madam Chair, I'm open to any questions from the commission.
Commissioner Calderon.
Thank you, Madam Chair. I appreciate everybody. This comment really is pertaining to myself personally, not to be taken by my other commissioners in any way, hopefully. But I think the rules, the trainings, and the requirements need to be a lot more stringent if any of us commissioners are going to be appointed as a hearings officer. The idea of having the ability for the chair to appoint Superior Court justices are people that have been doing this at that level for a very long period of time and clearly have a lot more experience, training, education, and knowledge than we would as sole commissioners. So if we're going to go down this road, I think respectfully to the general counsel, I think just general trainings is not enough training. And I would strongly suggest that we leave this capabilities in the hands of the retired judges that the chair appoints.
If I may clarify or address the concerns of Commissioner Calderoni.
Yes, but would you mind taking down the PowerPoint so that I can see all of the commissioners?
Sure.
Sorry. Go ahead, please, LaRonica.
Commissioner, these hearings take place within 15 days from the point of assignment. We've had one matter that has gone before a single commissioner, and Commissioner Kazaroshan was our presiding officer in that. We understand the concerns here. Pursuant to the regulation, however, the chair has the authority to appoint any of you who wish to serve in that capacity. but it is discretionary if you choose to serve. What we are offering and would look to develop and expand upon is something for those of you who choose to do this to have as a guide. We have a senior legal advisor who has served in the capacity as a Superior Court judge. He would be able to provide some assistance in that arena. We have different programs that are offered that the General Counsel becomes aware of. He would be able to direct us, as he does with the staff, to training on adjudicatory matters. So this one is in fact separate pursuant to the regulation from that hearing officer appointment, in that the regulation gives those of you who choose to serve the ability to be appointed by the chair. With regard to more stringent policies, we can take that under consideration. We do want to leave the opportunity, however, to continue to update as we learn about adjudicatory changes. As our commission grows, we want to have the ability through our general counsel to educate and train our presiding officers on those matters. So that's where you see the latitude that's being afforded with the development of programs or with the recommendation of programs.
I appreciate the input, LaRonica, and I agree with everything that you're saying. As far as training, continued education for all of us on the commission, it's indispensable. Gives us a better understanding of what the requirements would be and our duties here as commissioners. I just strongly think that, and I understand the statute and the ability for the chair. I just think it should be said openly in this meeting that there are people with much more experience than I as a commissioner. I won't speak for everybody, but I as a commissioner would rather delegate that authority to somebody that is far more advanced than I. I don't believe there's any classes that I can take that would put me at their level to make a determination of fact down the road. But I do appreciate the explanation.
And if I could add one thing before I turn to the commissioners with their hands in the air, Commissioner Calderon, I am so mindful as your chair of the extent to which all of the commissioners are incredibly occupied with other professional matters. And I am very sensitive to that fact. And I'm very appreciative of the extent to which all of the commissioners who have other tasks, every single other commissioner is very heavily occupied professionally in other matters. And I'm mindful of that as we would ever consider the possibility of utilizing this procedure. So please understand that. And I think Commissioner Luma, you had your hand in the air.
I just want to say, I absolutely appreciate your concern, Commissioner Calderon. At the same time, I think, we all kind of were appointed with knowing that this was a possibility and a responsibility. I also have complete faith in the training that the legal team will provide to us. I think, we've made tremendous progress over the past couple years that the commission has been, we've been on the commission. So I think that they can provide us the necessary tools in order to do this job and to do it well, not as effectively as someone who has decades of experience, but I think we all bring something of value to the table, regardless of what our experiences are. And I think it's just an obligation that we have.
Thank you. Commissioner Keserosian.
Just quickly, from in my one experience doing this, and I have done it in other in my capacity as on the Board of Bar Overseas, but this is a much different level than having a full hearing in front of a Superior Court judge that we had just talked about in the last issue. I don't know if that's helpful or reassuring, but it is a very different level of participation. And I think that with the training, I think it's important to have us all have the availability, or if you so choose to be able to do this. So it's doable.
Thank you. Commissioner Bluestone, please.
Yes, thanks. I just wanted to add, although I think that these comments have already come across, that that I think that the fact that we're a civilian commission is an important factor, and that there may be times when it's an officer's preference to have a hearing before a single commissioner. And I certainly trust the discretion of the chair to determine whether the commissioner is a good match for a particular type of hearing. And with the training that's provided, I also have faith in any of my fellow commissioners that that they would do a good job being the standard holder for this group.
Thank you. Any other comments? If not, let me ask for a vote on this policy. Commissioner Bluestone,
Yes.
Mr. Calderon,
Yes.
Mr. Crispin,
Yes.
Mr. Hall,
Yes.
Mr. Kazarosian,
Yes,
Mr. Luma,
Yes.
Mr. Tally,
Yes.
and I'm also affirmative. This is unanimously carried. LaRonica, have we addressed everything that you wanted to address with regard to policy?
We have. That concludes my presentation. Thank you, Commissioners.
Thank you very much. Moving on to the agenda, there are no matters which were not anticipated by me at the time of posting, and therefore I will now entertain a motion to go into executive session in connection with the statutory requirements that are laid out in our agenda under Chapter 30A. We will be addressing reports of preliminary inquiry in 3 cases. We will be addressing requests for approval to conduct preliminary inquiries in 8 cases, the numbers of which are in our agenda. We'll also be addressing approval of the minutes of the last executive session, and we will be discussing the existing litigation in Suffolk Superior Court.
I cannot hear you, Chair. Is anybody else having a problem, or is it just me? I don't hear you.
I can hear you fine. I don't know.
Me too. I can hear her fine.
And Commissioner Hall, I'm sorry, what?
That's okay. I can hear you now. I can hear you now. You went out for a minute.
I apologize. I am, what I said essentially was that we will be, I would now entertain a motion to go into executive session pursuant to the items that are laid out in the agenda, the statutory references to take up the matters that are laid out there. Okay?
Yes.
Now, did I see something from? Yes, Randy, please.
Madam Chair, could I just ask you to recite, assuming you continue to agree with this, the finding regarding the litigation provision that an open meeting may have a detrimental effect on the litigating position of the post commission? Do you find as much?
And I'm sorry, and now I'm having a little difficulty with the request. Just try again, please.
I'm sorry, that provision of the open meeting law calls for the chair to make a statement in the open meeting that an open meeting to discuss that issue would have a detrimental impact on the litigating position of the public agency. So
understood. The chair should never make any effort to short circuit anything at all that is suggested by our general counsel. Among other things, fellow commissioners, we will be moving into executive session pursuant to Chapter 38, Section 21A3 to discuss strategy with respect to litigation because an open meeting may have a detrimental effect on the litigating position of the post commission. So I think with that, I would entertain a motion to adjourn. Is there such a motion?
So moved.
Thank you. Commissioner Bluestone,
Yes.
Mr. Calderon,
Yes.
Mr. Crispin,
Yes.
Commissioner Hall,
Yes.
Mr. Kazarosian,
yes.
Mr. Luma,
Yes.
Mr. Tally,
Yes.
and also affirmative. Let me once again thank all the members of the staff, both those who have presented and those who have worked on the presentations. I know I speak for my fellow commissioners in thanking you for the extraordinarily difficult, important, and significant work that you are doing with regard to the objectives of the post commission. Let me tell the members of the public that we are grateful for your attending today. We will not be resuming any portion of the public meeting after our executive session. Enrique, do you want to just remind the members of the public, if they wish to ask questions of anything we have taken up, how they can do that?
Yes, thank you, Madam Chair. They can always find us in our website. We have a new website, as I reported earlier, but the old website redirects to the new website, mapostcommission.gov rather, excuse me. They can find all our contact information prominently displayed there.
All right. And then again, thank members of the commission. We will take a 5-minute recess. And there's a new, Jamie, is there not a new link? Thank you. Thank you. So at this point, this is concluded.